Glad to see that there's so much interest in this issue, and I hope that you're ready for a very informative presentation. And I just want to take just a minute just to thank our partners in sponsoring this event, Bob Bort and Ernie Bim of the Central Labor Council and Building Trades Council of Humboldt and Del Norte counties, and Tracy Cattleman of the Alliance for Sustainable Jobs and the Environment.
Peter Clapp is a graduate of Columbia University, has his bachelor's from Columbia University, and he has his law degree from Hastings College of Law in San Francisco. He was a corporate bankruptcy attorney for 20 years with the international law firm Skadden Arps, and he is now retired. He lives in the Bay Area. He has a consulting legal practice, and he teaches business law at the John F. Kennedy School of Law down in the Bay Area. With that, please give him a warm Humboldt County welcome.
Chapter 11 and bankruptcy law and about PALCO. Those are the subjects. But some of the stuff about bankruptcy law is general bankruptcy law. It doesn't particularly, that applies to all cases, not just PALCO, and some of it's PALCO specific. So if you're really interested just in PALCO, you may have to sit through a little bit of general bankruptcy law, but I tell you, if I can do it clearly, it will help you understand what's happening in the PALCO case. And I want to start by referring you to the chart that's on the wall behind me and also on the first page of the program. Did you get a program? Good. And if you didn't get a program, raise your hand and someone will bring you one. If you look at it, you'll see at the top is Mr. Horowitz, and this should say Charles Horowitz and other shareholders. They own Maxim. Maxim owns a company called Maxim Group Inc., which owns Mark, where's Mark? Doesn't PALCO own Brit, Santa Cruz, Scotia, and they're all subsidiaries of that? All right. Maxim Group Inc. owns all of these companies, and these are the companies that have filed for bankruptcy. So that's, I don't know if that's right either, because if there's 6 bankruptcy cases or 5, I apologize. These are the companies that have filed for bankruptcy, and you need to look at them specifically. As you know, way better than I do, Pacific Lumber and Scotia Pacific are different companies. Pacific Lumber owns the mill. Scotia Pacific owns the timber. It owns the trees. Scotia Pacific also is where most of the debt is. Most of the debt is held by note holders, and you can consider note holders as just a different kind of bank. It's $716 million instead of one person lending it, a whole bunch of people lend it. And in $1,000 increments, and those are called notes. And there's $716 million of notes outstanding. And those are, that's a loan to Scopac. So Scopac has the trees, and Scopac has the debt. That debt is secured debt. That means that the note holders have collateral, and it means that if the Scopac fails to make payments on the notes, the note holders, the people who hold the debt, can foreclose on their collateral. Just like if the bank had a mortgage on your car, on your house, or a lien on your car, and you didn't make the payments, the bank can take the house or the car. Similarly, if Scopac fails to make payments on the notes, the holders of that debt can take the trees. If you have a payment on your house, you might have $500 or $1,000 of interest due every month in order to stay out of default and keep the house or the car. In order to keep the trees, Scopac has to pay $54 million in interest every 6 months to the note holders. Why did these companies file today? You will read in this paper, when you hear about bankruptcy, you'll read that the company filed for protection from creditors. That's a standard phrase you see in the newspaper. What does that mean, protection from creditors? When a company files for bankruptcy, or when an individual files for bankruptcy, their creditors, the people they owe money to, have to stop all collection efforts. They can't sue them, They can't garnish their wages. They can't foreclose on their collateral. Bankruptcy stops all that. So if you see an ad in the TV, are people garnishing your wages? Are people threatening to foreclose on your house? Call me. That's a bankruptcy lawyer, and he's going to file bankruptcy for you, and that will stop the garnishment or the foreclosure. In this case, as you know better than I, SCOPAC had an interest payment due in January, and they didn't have the $54 million. So they couldn't make the payment. And under those circumstances, the note holders have the right to foreclose on the trees, foreclose on their collateral, the timberland. And it's to stop that foreclosure, to get protection from creditors, that SCOPAC filed. They filed under Chapter 11 of the Bankruptcy Code. The Bankruptcy Code is a federal law, so it applies throughout the country. It's the same law throughout the country, and it has different sections that you can file under. And they filed under Chapter 11. That's the business reorganization section of the Bankruptcy Code. So if it sounds like, so bankruptcy is a scary word, and it sounds like, holy cow, bankruptcy, we're out of business. In fact, if they had filed under Chapter 7, then they would be going out of business. But Chapter 11 does not mean the end of the business or the end of the company. Normally, companies file under Chapter 11 because they believe they have a viable company, but they have to fix some problems. They have to reorganize in order to make the company profitable. In this case, they need to reorganize their debt to get out from under the burden of the interest payments. And Mark points out to me that it's $54 million a year. It's $27 million every 6 months. So they filed for Chapter 11. And I want to talk a little bit about how a company operates in Chapter 11. And I'll take this off. What is Chapter 11? If you borrow money from the loan shark and you don't pay the loan shark will come and he has a collection technique. There's a procedure that the loan shark will follow in order to collect the debt. And there's different ways that this issue can be handled. Here we have a situation where the borrower, SCOPAC, can't pay what it borrowed to the note holders. So the note holders don't send around Tony Soprano and his friends. Instead, this process is resolved in bankruptcy court. And there's special rules as to how bankruptcy court works. Bankruptcy court is a forum for and I apologize for my handwriting, it's a forum for the resolution of the dispute between the debtor and the creditors. The debtor is a company that owes money, in this case it's Palaco and SCOPAC. And it's a dispute, the resolution of the dispute between those companies and the people they owe money to, which in this case is principally the note holders. They owe money to a lot of other people, including perhaps people in this room. But the $760 million to the note holders is the largest creditors. And what's the dispute? The dispute is, are the creditors going to get paid? How are they going to get paid? How much are they going to get paid? And when are they going to get paid? I used to know a bankruptcy lawyer that I admired a lot, and he said he always, in corporate bankruptcies or in any kind of bankruptcy, he'd always much rather represent the person who owed the money rather than the creditors, because he said when you represent the creditors, you only say one thing: where's my money? Where's my money? Where's my money? When you represent the debtor, you have to keep creatively coming up with answers to that question. So it's much more challenging job.